Good afternoon. Today I'm here to announce that government will seek to introduce new pathways to permanent residency and Bermuda status. This will advance human rights in our island to bring us in line with important international human rights standards. These amendments will be contained in the Bermuda Immigration and Protection Amendment Act 2016, which government intends to table in the House of Assembly in the coming weeks. First, let me acknowledge the presence of my junior minister, MP Sylvan Richards. I also acknowledge the presence of my colleague, the Attorney General, the Honorable Trevor Moniz, JP, MP. He has rendered much assistance to our team in respect of the policy initiative that I am about to announce. This announcement today should finally bring the much-needed security and peace of mind to those in our community who have come to call Bermuda their home, but yet legally are viewed as outside guests here. They do not know what Bermuda holds for them in the future. They are our neighbors and our friends, people who have put years of hard work and dedication to build Bermuda up. Their children were born and raised here, and some of them were even born here themselves. They provide jobs for Bermudians, they eat in our restaurants, they rent our homes, they tend to our sick, they walk the beat and protect us. They volunteer their services to charities. They love Bermuda just as much as we do. I know many of you will have questions, so let me get into the details for you now. I want to begin by stating something which I find quite shocking. Bermuda is one of the only places in the world that does not have a pathway to status that isn't through marriage. Let me repeat that. Bermuda is one of the only places in the world that does not have any pathway to status. Turks and Caicos is the only other British overseas territory which does not have a pathway for belonger status. Many other small jurisdictions like Bermuda also provide such pathways. Anguilla allows for permanent residency after 7 years and belonger status after 15 years. The Falklands allows for belonger status after 7 years. The British Virgin Islands allows for belonger status after 21 years. Other small island and Caribbean jurisdictions allow for citizenship after as little as 5 years and as much as 25, with most averaging in the 8 to 10 year range. The unfortunate reality is that Bermuda's immigration policy has allowed substantial numbers of workers and people to live in Bermuda with no real hope or expectation that they can ever achieve the full rights associated with being Bermudian. Likewise, permanent residents are growing up and having children of their own, and to these children, Bermuda is their only home. They know no other place. The plight of people affected by our current restrictive immigration policy is a long-standing problem faced by successive governments. There was a time when the grant of Bermuda status was discretionary. This was done away with in 1989. Under the OBA government, we will never go back to a system of discretionary grant of status. Our legislation minimizes the opportunity for ministerial discretion and for ministerial abuse. The removal of those provisions led to increasing numbers of persons for whom Bermuda is home without any legal right to Bermuda status. This is in fact contrary to international law. Past immigration policy has involved periodic amnesties for the grant of Bermuda status. The UBP government enacted amendments in 1994, which allowed for those born in Bermuda or who arrived before their 6th birthday to make an application upon turning 18 and before 2008. This legislation introduced a moratorium aimed at taking a pause in respect of immigration policy. In 1998, the government then introduced the possibility of working residential certificates, which amounted to a form of conditional residency for persons who continued to be employed in Bermuda. This did not, however, meet baseline international standards. During its final years in office, the UBP was never able to come to a fair or sustainable solution to the question of Bermuda status. As time went on, more and more people were setting down roots in Bermuda with no solution in sight. At the end of 1998, the PLP took power. However, in their 14 years at the helm, they too failed to properly address the issue of Bermuda status. In 2002, the government introduced limited rights to apply for Bermuda status and allowed long-term residents to apply for permanent residence certificates, or PRCs. The number of persons eligible for Bermuda status was very small. Instead, most long-term residents were caught by the PRC provisions. Permanent residency was available to non-Bermudians with over 20 years of continuous residence and demonstrated good character and conduct. These persons also had to be ordinarily resident in Bermuda before the 1st of August 1989 and be at least 40 years old on the date of application. A secondary group of non-Bermudians could apply for permanent residency if they were closely related to Bermudians and other permanent residents. My honorable colleague, the Attorney General, would be intimately familiar with the history I've just relayed and the issues underlying these fits of reforms. Members of the public will undoubtedly recall his participation in various grassroots efforts to reform the law in a previous time and while wearing a different hat. It is for that reason he is joining me here today, and he has been a tremendous help in bringing this policy to fruition. During this time, and as a complementary policy initiative, the PLP put in place term limits for non-Bermudians. I have previously spoken about how ineffective this policy was for protecting jobs for Bermudians. The reality is that extensions of term limits were regularly given. In excess of 70% of people who applied for waivers of term limits were granted such waivers. The highest number of work permits ever processed happened under the PLP government in 2008, with 8,699 permits to be exact. For comparison, 4,207 work permits were processed in 2013. This directly contributed to the policy issues we are now facing with long-term residents in Bermuda. I would be remiss if I failed to mention efforts by the previous government when enacted the Incentives for Job Makers Act 2011. Immigration legislation was amended to allow senior executives who helped create jobs for Bermudians and who have been exempt from immigration provisions regarding work permits for at least 10 years to obtain permanent residency. While efforts to attract investment in Bermuda should always be lauded, in the government's view, an immigration policy which fails to address private and family life categories of immigration is an incomplete one. This government made a commitment in its November 2013 throne speech to undertake a review of immigration law and to look at certain new pathways for status. As my ministry began to look into the matter further, and as more cases of hardship caused by the current laws in place came to my attention, it became apparent that more fundamental reform was needed. Many decisions of the Immigration Appeal Tribunal, all of which are published on the Department of Immigration website, represented further interventions requiring a policy response from government. Taken together, it became clear that the government needed to come forward with more fundamental reform, a position we note with that the opposition agrees. Then came the Supreme Court decision of Carn and Correa. That case gave us a ruling by the Chief Justice clarifying the fact that permanent residents who were ordinarily resident in Bermuda on or before the 31st of July 1989 could apply for Bermuda status. It was always government's preference to 1. Address the question of persons born in Bermuda or who arrived at a young age, 2. To mitigate the unfairness of different individuals in the same family obtaining Bermuda status, and 3. To clarify the circumstances when children adopted by Bermudians could obtain Bermuda status, and 4. To avoid a growing crisis of potential statelessness of non-Bermudians born and living in Bermuda. The fact is, we have been overtaken by events. The Chief Justice's decision in Carn and Correa represented yet another factor which had to be taken into consideration when crafting this policy. To summarize from this short history, the following are the recurring themes of immigration policy in Bermuda. 1. Stopgap measures that fail to produce long-term sustainable solutions. 2. Work permit practices which lead to a large pool of non-Bermudians in limbo. 3. A bipartisan understanding of the need to attract international business to Bermuda, but a corresponding failure to address the private and family life aspect of immigration policy. And 4. A failure to abide by baseline international human rights standards, including those standards in other small island jurisdictions which we are comparable to and competing with. The status quo is totally unacceptable. This is especially the case in a jurisdiction as modern and progressive as Bermuda. The status quo has led Bermuda to fall afoul of its international legal and human rights obligations under the European Convention on Human Rights and the International Covenant on Civil and Political Rights. Blanket bans on obtaining such residency rights, as is currently the case, are not consistent with the European Convention on Human Rights. Currently, permanent residency is available to senior executives who are job makers and who have been exempt from immigration provisions regarding work permits for at least 10 years. It is also available to an ever-shrinking class of persons who are the adult children and spouses of other permanent residents who in turn were in Bermuda on or before 31st of July 1989. There are no other pathways for long-term residents or family members to obtain permanent residency. In our opinion, an immigration policy that offers no pathway for long-term residency or for protection of private and family life is incomplete, unfair, and frankly wrong. Likewise, in terms of the granting of Bermuda status, status can be obtained by non-Bermudians in the following main circumstances: where an applicant has been married to a Bermudian for 10 years, with 7 of those years ordinarily resident in Bermuda; where an applicant is the adopted child of a Bermudian and makes an application after turning 18 but before turning 22 and has lived in Bermuda ordinarily for 5 years; where an applicant has been ordinarily resident in Bermuda for 10 years and has a qualifying Bermuda connection; and where an applicant is a permanent resident and has lived in Bermuda ordinarily since at least 31st of July 1989. In terms of providing pathways for Bermuda status, the main reforms we are now proposing will allow any permanent resident who is ordinarily resident in Bermuda for 20 years to apply for Bermudian status. In addition, such a person will need to be a Commonwealth citizen, must be of good conduct and character throughout the period of residency in Bermuda, and must not be convicted of offenses showing moral turpitude, as has always been the case. The legislation will make special transitional provision for those who are already in Bermuda for 20 years or more upon commencement, provided they are Commonwealth citizens. The legislation will also correct what, in the government's opinion, has been a grave problem with the legislation in respect of the adoption of children by Bermudians. Traditionally, such individuals were only deemed to be Bermudian until their 22nd birthday. They would then have to make an application for the grant of Bermuda status when they turn 18 and would have to have lived ordinarily in Bermuda for 5 years before that application. However, this leaves such children vulnerable to losing their chance for Bermuda status if that 5-year residency period is interrupted. The law also makes an unfair distinction between the natural-born children of Bermudians and those who are adopted by Bermudians. Therefore, the new legislation will rectify this by allowing the adopted children of Bermudians to automatically obtain Bermuda status, provided as follows: they are Commonwealth citizens, they were less than 12 years of age when they were adopted. In the case of an overseas adoption, the Bermudian parent is domiciled in Bermuda at the time of the adoption, and the adoption is recognized under the laws of Bermuda. This will therefore mirror the current legislative provisions in respect of those who obtain Bermuda status by birth. An adoption effected by the courts of Bermuda will lead to status for the child as from the date of the adoption order. An adoption from overseas will require a general inquiry to be made by the Department of Immigration, supported by an affidavit of domicile before the child can be registered as Bermudian. In terms of providing pathways for permanent residency, the main reforms we are proposing are as follows. Any person who is ordinarily resident in Bermuda for 15 years will be eligible to apply for permanent residency. In addition, such a person will need to be resident in Bermuda for 2 years immediately prior to his or her application, and must have been a person of good conduct and character throughout the period of residency in Bermuda. Also, any person who was born in Bermuda or who arrived before his or her 16th birthday will be eligible for permanent residency after 10 years of ordinary residence in Bermuda upon reaching their 18th birthday. In addition, such a person will need to be resident in Bermuda for 2 years immediately prior to his or her application, and must have been a person of good conduct and character throughout the period of residency in Bermuda. Additionally, any person who has a Bermuda close family connection will be eligible for permanent residency after 10 years of ordinary residence in Bermuda upon reaching their 18th birthday. In order to qualify for permanent residency under this pathway, the applicant must be the brother or sister of a person who possesses Bermudian status, or that person who is a brother or sister does not qualify for such grant. the natural parent of a person who possesses Bermudian status where that person does not qualify for such grant, the brother or sister of a permanent resident where that brother or sister does not otherwise qualify for such grant, the natural parent of a permanent resident where that natural parent does not otherwise qualify for such grant, the son or daughter of a permanent resident where that son or daughter is above the upper limit of compulsory school age, or the spouse of a permanent resident where that spouse does not qualify for such grant or the grant of Bermuda status. In addition, such a person will need to be resident in Bermuda for 2 years immediately prior to his or her application and must have been a person of good conduct and character throughout the period of residency in Bermuda. These permanent residency family provisions were introduced by the then PLP government in 2002. The major change being introduced is to remove the 2010 time limit for making such an application. It should be noted that there will be circumstances where the minister responsible for immigration will have the right to deny an application for permanent residency or status. For example, where a potential applicant does not meet the residency requirements or where any period of absence from Bermuda has not been authorized. This would not include work or education-related absences. The minister will have to consider all factors of a person's presence in Bermuda to consider whether he or she has been ordinarily resident, as has always been the case. In addition, no applicant will be successful if they have been convicted, whether in Bermuda or elsewhere, of offenses showing moral turpitude, or their character or conduct otherwise would disqualify them from a grant of Bermudian status. Finally, the amendments will clarify that the minister will have the power to strip anyone of Bermuda status or permanent residency following any application which was obtained by means of fraud, false representation, or the concealment of any material fact. Apart from the fact that making these changes is simply the right thing to do, and is long overdue, it almost goes without saying that there will be numerous benefits to Bermuda as a result of this legislation. Firstly, it will help to increase the size of Bermuda's working population in the face of declining birth rates and a shrinking Bermudian population. It is no secret that Bermuda faces real demographic challenges in the coming years. The reality is we have many more Bermudians who are getting older and fewer younger Bermudians who are able to pay into our social insurance, pension, and health insurance systems. Our non-Bermudian population is far younger. Those who are ideally placed to benefit Bermuda in the long run are those who have already demonstrated their commitment to Bermuda through their long-term presence. As Bermudians begin to retire, they will appreciate the presence of younger workers who ensure that our social safety net continues to be affordable. There are many other very pragmatic, immediate benefits. New applications will represent a revenue-enhancing opportunity as applicants pay the substantial fees involved under the legislation. New Bermudians with their newfound security could seek to purchase real estate or inject capital into Bermuda's companies as directors and shareholders. Assets which will be earmarked to leave Bermuda will be more readily available for investment in the local economy. These contribute to an economic multiplier effect and feeds back into a positive movement in Bermuda's balance of payments and increased government revenue. There are some who will say that acting to provide pathways for residency and status will take jobs away from Bermudians. This will not happen. We are dealing with very small numbers of persons who may qualify. The 2010 census data revealed a total work permit population of 6,421. Of that, 5,738 had been in Bermuda for less than 15 years. 511 had been in Bermuda for 15 years or more, and assuming that the 172 who did not report were in the latter category, we are dealing with 683 possible applicants likely to be able to make applications upon this legislation coming into operation. However, there are two further factors to consider. The census data is now almost 6 years out of date. With work permit processing cut in half since 2010, many of those work permit holders will have long since left Bermuda. Very few numbers are likely to qualify in the coming years if and when the proposed legislation is enacted. The Department of Immigration estimated that 1,455 PRCs were potentially able to apply for Bermudian status following Karna and Korea. Just over 760 have submitted applications. With a take-up rate of just 50%, we believe that not all work permit holders would rush to submit their applications upon enactment of the legislation. What will ultimately decide the numbers of persons who stand to benefit is the existence of a work permit policy which is robustly enforced. This government has done more than any other to ensure that there is a fair playing field for Bermudians seeking work in this community. We introduced civil penalties of up to $10,000, which may be levied by the Chief Immigration Officer against companies and individuals alike, and these penalties are regularly imposed. We doubled criminal penalties for work permit-related offenses. All employers must now advertise all available positions prior to applying for a short-term or standard work permit for a minimum of 8 consecutive days on the Bermuda Job Board. The Bermuda Job Board now features information on expiring work permits, which will allow candidates to prepare themselves for upcoming potential jobs by ensuring their skills are relevant to the required skills needed. And the Ministry of Home Affairs, through the efforts of the Department of Workforce Development, is ensuring that Bermudians are retooling and retraining for the jobs of today and tomorrow. In contrast to the opposition on work permits who talked tough and hoped that no one would notice the flimsy record underneath that rhetoric, the OBA government is tough in ensuring that Bermudians come first in our employment market. However, more important than the economic imperative, I hope the Bermuda public will agree that this is the humanitarian and right thing to do. I have spoken already about the need to bring us in line with international baseline standards seen in other jurisdictions and established in international law, and I have spent some time with various representatives of community organizations and have heard the issues that exist. Many individual commentators in the community would undoubtedly and sadly like to paint these reforms as anti-Bermudian. There is nothing anti-Bermudian about helping our family, our friends, and our neighbors. The people we are talking about represent every class, race, ethnicity, and national origin. Like the Good Samaritan tending to the needs of his neighbor, we Bermudians are kind and compassionate, and we are our brother's keeper. We all have an interest in making sure that the links we have with people fully enmeshed in this community are maintained. And I am sure that everyone in the community will know of someone who has been adversely affected by a lack of protection in our immigration policy. You would be shocked to hear from the people that I've heard from since becoming minister responsible for immigration. I hope to share with you some of these stories in the coming weeks, like the 34-year-old nurse who came to Bermuda from Jamaica at age 7, who was on a work permit with no rights despite being here in Bermuda for 27 years. Or the young man who came to Bermuda also at age 7 from the Azores and is now in his late 30s, but lost out on status because of a 2-year absence from Bermuda due to family illness. Or the dozens of others who've obtained PRC under the previous government, but who now essentially have stateless children. I recognize that there will be among us some who have questions or concerns, and I certainly welcome any frank and open discussion from those individuals in the weeks to come. I have provided a short guide on the effect of the proposed changes to the legislation, which I hope everyone will read. I urge everyone to engage in constructive dialogue in respect of these important changes, and not engage in fear-mongering or misinformation campaigns. We are not talking about opening floodgates. We are talking about the right thing to do. And I believe that these changes should accordingly be fully embraced. Thank you.
Any questions from the audience? Just work my way that way.
Minister, you say
Yes.
the people we are talking about represent every class, race, ethnicity, and national origin.
Yes.
And yet, you previously said that it's reserved only for Commonwealth citizens.
In respect of the ability to obtain status, how it would work, someone would have to become a permanent resident if they're non-Commonwealth, and then they would have to fulfill the conditions under the British Nationality Act to become a Commonwealth citizen. That means an additional 1 year of residency. Then they would be able to make an application for status. The requirement has always been in Bermuda, to obtain status, you needed to be a Commonwealth citizen.
Why?
That is something that is related to the British Nationality Act and has always been in Bermuda law since the inception of the Immigration Act.
Any questions from you, Brian?
morning, Minister.
Good morning.
You probably already addressed this part with respect to those who qualify, first of all, for permanent residency. I take it this proposal will be retroactively, so those who are already here won't have to start the clock.
Correct. What we would be looking to do is that upon the date of commencement of the legislation, when that happens, is if you have already been in Bermuda for 20 years at the date of commencement, then you would not need to become PRC first. What we're proposing here is that in order to obtain status, in the usual course, you will need to become a PRC. So you'd make an application for PRC after you've been a resident for 15 years as ordinarily resident. And then once you hit 20 years, you'd be able to make an application for status. But we would expect people to be PRC first, save for when the legislation comes into effect. If you have been here for 20 years upon the date of commencement, you can skip the PRC piece and apply for status.
Lastly, I'll address the 800-pound gorilla in the room, and that is by this proposal, your government will be accused inevitably of attempting to, quote, whiten the population or alter the population so that in the next election you'll have additional electoral support. You want to address that?
I'm happy to, because to be perfectly frank, I think that falls into the category of misinformation and fear-mongering. And what we will be doing over the course of the next number of weeks is sharing the data that we have collated in respect of those individuals that have been here for the amount of time and essentially the jurisdictions from which they come. I think you will also hear further details from what the opposition has said over the years in respect of the fact that in reality the numbers of people who end up getting status doesn't have an effect on the history of elections in Bermuda. And it's dangerous in any way to presuppose how someone votes. And that's the problem that we need to get away from in Bermuda. There's a presupposition that everyone that is going to get something is white and will not vote for the opposition or will only vote for the OBA. And I dismiss that, and this government dismisses that, and the more that people say such nonsense, it doesn't get us very far in Bermuda's history. It just doesn't. So that is not an 800-pound gorilla in the room to me. What that is strictly misinformation and scaremongering.
So you would disagree with officials from CURB, for example, who say that past actions by the former UBP government to grant mass status to Commonwealth citizens led to an alteration of the voting base. And we know through numerous data that it's no secret that when it comes to race, who votes for who? It's clearly in all the surveys we read.
Right. I think in the past, the way in which things were done in relation to status was designed purposefully for what CURB has been talking about. Without any doubt at all, when you had very short residency requirements, and at that time when decisions were made in the 70s, decisions were made, in my view, based on the racial makeup of the country. That is a long, long time ago. And I can assure you that this government has not taken any such matters into account whatsoever in respect of what is ultimately the right thing to do. So again, what you're assuming is that the majority, or the vast majority of those who might be entitled would be white, because that's essentially what you're saying, and then you're also saying that all of those people would ultimately vote for the governing party. I don't believe that for one moment, and the data that is there shows that that is simply not the case. So again, I think that what we need to be focusing on are the human stories of why some of these things have to happen. We've explained in our statement that we have very serious issues in relation to the European Convention on Human Rights. That needs to be addressed. And I dare anyone to look in the face of someone who's been here their whole life and tell them they're not welcome after they've committed their lives to this country, and then we say to them, you're not welcome, when we're welcome as Bermudians everywhere in the world. I don't buy it, Tarai.
And lastly, you said next coming weeks you'll be commencing a campaign to share those human stories.
Yes, I mean the intent, yeah, absolutely. What we've provided for you today is a small breakdown of essentially what I've tried to get across today. We've given a lot of detail, and we've done that purposefully today. We've put a lot of information out there so that people cannot say we haven't shared it. But you will appreciate that many people in this community have kept their head below the radar for the fear. And we have seen in Bermuda what happens sometimes when misinformation is allowed to take control. And it is my belief that those people who will tell their stories, that everyone in this community knows people like the people that you will hear from, without any doubt whatsoever. I would bet everyone in this room knows people or has family or friends that have been affected by immigration law and policy that is wrong.
Okay, no further questions? Oh, one from Gerald.
Good afternoon, Minister.
Good afternoon.
Can I just clarify, please? Does this affect only people on the island now?
No, there will be no ultimate cutoff date. What has happened in the past is legislation has said you must make an application by a certain date. So under the old PRC legislation, you could be in Bermuda for the 20 years, but if you missed that cutoff date of 2010, you were no longer able to make that application.
So just again to clarify, going
Yes.
forward in 20 years' time,
Mm-hmm.
will people be able to apply for residency?
Correct.
Right. So it's fairly open-ended then?
It's open-ended, but
So
I
the
think...
numbers are anybody's guess, aren't they?
Well, it's anybody's guess in terms of going forward, but I don't accept that. Where I'm going with this is to say we have a significant population decline in Bermuda. And any commentator who has looked at the data knows that that is the case. We have a declining birth rate and a rising death rate. Bermuda is simply unable to sustain itself in respect of the amount of social services that need to be paid. One way to help us sustain ourselves is to give some certainty to those who have been in Bermuda for a significant period of time. I think I would probably accept some of the criticisms if we were saying to people, as Tarai has said in the past, when people could vote after being in Bermuda for 3 years or 7 years, or they somehow got some major rights after a very short period of time. We're talking about people ultimately who will have been here for 20, and that is a significant and very long period of time.
Understood, but it's a
Yeah.
certain it's a degree, it's an open door, isn't it?
It's well, not when you take into account how work policy works. What we have done, in my view, very well is in the last 3 years we have put in, as I've explained, increased penalties. We have a regime where people are in fact getting fined. We have caught people out, and we have a policy that is working. And we have that ability now to do that. With Job Board, more and more Bermudians will get the opportunities. So what you don't want to see, you don't want to be in a position where you have 10,000 work permits being given out every year, because you have work policy that's robust. And individuals that happen to be able to remain in Bermuda for 20 years means that they're either needed in the community or Bermudians are not qualified.
Bearing in mind my first question,
Mm-hmm.
would this not have been better done as an overall review of immigration policy, as Walton Brown has called for?
I think that we have spent, well, I know we've spent 3 years looking at this policy. We have done a significant amount of work, and as we had begun the exercise simply by looking at some smaller inequities to do with adopted children, to do with people who had been born here and had been here a significant amount of time. But as you start to also lose immigration appeal tribunal cases on the basis of human rights issues, you have to start looking even more.
So wouldn't it have been better to be part of an overall...
That's exactly what we've done. We've laid out here for you in a 14-page document a substantial amount of changes that will be have an effect on where we're going, and in my view a very positive effect.
You mentioned it's contrary to international law.
Mm-hmm.
What law is that?
If you look at the European Convention on Human Rights about rights to family life, and if you spend some time, and I invite you to look at some of the immigration appeal tribunal cases that we have been at the wrong end of, you'll see that this has become our consistent theme, that we are in breach. We have received also a view from the UK that demonstrates that in fact our way of doing things is not the right way. And in our view, ultimately we'd be challenged in the opportunities here.
So how much is this driven by the Human Rights Act or Human Rights Law?
It's also partly driven by what is simply the right thing to do.
But would you face a successful challenge into the Human Rights Act?
It's our view that we would not be successful if someone was to challenge.
So you're preempting what might happen in the courts?
As part of this, yes, we would be. Yes.
Okay, thank you, Minister.
Yeah.
Did you have one question, Jennifer?
Come on.